We really appreciate your participation in this important discussion about the Stop Woke Act. And Business for America wanted to organize this conversation today to look at the business implications of the action by the Florida State Legislature and Governor DeSantis in enacting the Stop Woke Act. And just a quick history on that piece of legislation. Woke, by the way, stands for Wrongs to Our Kids and Employers Act. The legislation is technically known as the Individual Freedom Act and was passed late last year, signed into law by Governor DeSantis, and then, as we're going to learn, was challenged in court by Protect Democracy, who succeeded in securing a preliminary injunction against the employer provisions of the legislation. The state is now challenging that, is appealing that injunction, and a decision will likely be made in the 11th Circuit Court in Florida sometime early next year. But the reason that Business for America is interested in this topic really relates to our broader work on the health of democracy. And as we see over the past several years, as legitimacy of our institutions are challenged, we also find that business has become a target. And the instance here in Florida very much makes the business community a target in what we are concerned about is an erosion of our norms and historic standards about what constitutes a healthy democracy. So we're concerned about that trend in Florida and elsewhere in the political environment. And then we're also concerned basically about corporate free speech and speech codes, and how the code in Florida could act to stifle free speech within the corporate community, imposing the possibility of lawsuits by employees and impairing a business's ability to operate productively. So those are all topics we're going to focus on here during the conversation. We very much want your participation. If you have questions, please pose them in the Q&A function at the bottom of the screen, and we'll make sure to try to get to all of those as we can. And then also, I want to just make sure people know that there is a business sign-on letter that Protect Democracy has produced. We will make sure you have access to that. And there is also an amicus brief that Shalini is going to describe to us in a little bit more detail. Okay, so that hopefully gives you the context of why we're having the conversation and the consequences of this piece of legislation to the business community, broadly speaking. So let me first turn it over to my colleague, Sarah Bonk, to give a little bit of detail on why Business for America is interested in this topic and the type of work that BFA engages in.
All right. Well, thank you so much. Really appreciate that, Richard. And thank you to everyone for joining us today. So as Richard alluded to, Business for America is a business membership organization, national, nonpartisan, nonprofit, and we're focused exclusively on how companies can help foster a healthy representative democracy and more effective government. Our companies come from across the country and all different sectors and sizes. Our members are Fortune 500s and all the way down to small startups. And at the core of our mission is the understanding that the business community has a bottom line economic interest in protecting our democratic institutions. We believe that talking about the problem is not enough. It's time for businesses to take meaningful action toward the preservation of our democratic republic. And since our founding, we have had a variety of business initiatives. We coordinated donations of PPE to election officials in 2020. We advocated for election cybersecurity policy, as well as voting rights and accessibility in 2021. And right now we're supporting bipartisan federal legislation for civics education, as well as reforming the Electoral Count Act to ensure the process for counting electoral college votes is crystal clear in every presidential election. But as we've done all this work, so far, we haven't worked directly on the issue of free speech. And I hope that everyone joining this webinar would agree that free speech is protected by the US Constitution and is an essential part of our democratic institutions. As Richard noted, today we'll be talking about the Stop Woke Act and how it targets business workplace speech around diversity, equity, and inclusion. And it's important to note that the question here is not whether DEI training is useful or effective. It might be terrific, but it might be ineffective or even counterproductive. That's not the issue. The relevant policy question here is who gets to decide what goes on in your workplace? Who gets to decide what kind of speech your company supports and engages in? What we're talking about here is a state government regulating the free exchange of ideas. And at BFA, we think your business should have the freedom to foster a workplace culture of your own choosing. We think your business should have the freedom to experiment with that and the freedom to fail. It's not the government's job to decide that. When we consider new laws or regulations, it's essential to look at the underlying principles. And one of BFA's principles is that we need rules that make sense no matter who is in charge. So you might like a particular restriction on speech, but it's essential to remember that these rules can be turned around and used against speech that you do support. It's not that difficult to imagine lawmakers in a blue state passing a law to limit companies from espousing certain values in the workplace, like let's say Hobby Lobby's Christian values, or Black Rifle Coffee companies pro-military and pro-Second Amendment views, right? So we think, let's not give politicians the ability to define and restrict what constitutes acceptable discourse in the workplace. Chilling the free speech of ideas is a bigger threat to our liberty and to American values and to our representative democracy than wokeness could ever be. So with that, I'll hand it back to you, Richard.
Great, good, thank you. So let's learn a little bit more about the legislation and the history of this act. And Shalini Agarwal is the lead attorney on this lawsuit and is counsel at Protect Democracy. And we've had the real honor of working with Protect Democracy on a number of initiatives over the past year and a half, and are really happy to have Shalini with us this morning to describe the history of the lawsuit and what companies can do about it. So I'll turn it over to you. Thanks for joining us.
Thank you. So Shalini Goel Agarwal, and the short version of the presentation is that the state of Florida, at the urging of our governor, enacted the Stop Woke Act to crack down on what he's calling woke corporations, to restrict speech about DEI in the workplace. And the employer provisions of the law are currently enjoined, which means they're basically suspended because of the lawsuit. And we are looking for your help to make sure that it stays that way. So more details on how to do that to come. How we got here. So the story of how we got here is an example of how authoritarian ideas can take root and gain traction in a different context. The idea for the Stop Woke Act and other sort of copycat bills all originate back to late 2020 with a Trump executive order. So in 2020, then President Trump enacted an executive order at the urging of Chris Rufo, who many of you may have heard of or seen on Fox News, that was aimed at combating what they called the toxic propaganda, like critical race theory and the 1619 Project. And this executive order prohibited federal contractors from advancing certain race-related concepts. So if they advanced race-related concepts, they could not be a federal contractor. That was the structure of that executive order. And a federal court soon thereafter enjoined that executive order as a clear First Amendment violation, viewpoint discrimination, unconstitutional. Then President Biden took office, and when he did so, he rescinded that executive order. But then, lo and behold, a couple of years later, those concepts from the executive order reappeared and popped up in state legislatures around the country, largely focused on prohibiting faculty and staff at public schools, K through 12, public education, and also in universities from advancing any of these same concepts. So to date, at least 17 states, largely in the Southeast, have enacted, not just in the Southeast, but that's, I think, the highest concentration is here, other states as well, have enacted these types of laws that prohibit concepts related to race and sex discrimination from being taught in schools. So in Florida, we decided to go them one better, and our ambitious politicians have enacted the most extreme version of these laws. So in December of last year, Governor DeSantis unveiled the Stop Woke Act. And during the announcement, he talked about this bill as a tool to what he called take on corporate wokeness. And he characterized DEI trainings as basically corporate sanctioned racism. And he was going to put a stop to it with this law. So what makes Florida's law distinctive is our law, the Stop Woke Act, also regulates K through 12 schools, public schools. It also regulates public colleges and universities. But what makes ours unique is we also reach into private employer workplaces and regulate the speech of those private employers. And it censors basically the speech of private employers who want to conduct mandatory diversity, equity, and inclusion training for their employees. And, you know, as many of you who have had experience in Florida may note, restricting private sector speech in various contexts has been, that contradicts the views of the governor, has become sort of a political cudgel that's been used very frequently in the state. We see that with the targeting of Disney, which, you know, came out against the Don't Say Gay bill. You've seen that with the line item veto of the Tampa Bay Rays state training facility after the Tampa Bay Rays did some tweeting about gun violence. So there's a target on the backs of corporations in the state or employers who do work in the state as being woke. And so we think you all have a really important voice here and want to make sure that you're able to exercise it. So Protect Democracy typically has not been involved in issues like this. We largely focused on voting and regularity of, you know, electoral counts, focusing on protecting institutions of democracy. But we see this issue as really a central democracy issue because it is a speech code and it takes a page from what we call the authoritarian playbook. And what do I mean by that? Three factors here that we think makes this really like an authoritarian law. One, that it seeks to censor ideas that challenge government officials' preferred narrative. Two, it muzzles independent institutions, in this case, businesses who have an important voice to contribute to our democracy. And third, directs outrage toward disfavored groups, right? It's no accident that the speech being targeted here is about race and sex. And we think that these three factors turn this law into something that is authoritarian and deserves some pushback. So let's talk then about what the concepts are. What are these prohibited concepts that the law forbids employers from conducting mandatory training about? One is implicit bias. And I should say that the way that the law is structured, it's very vague, the language. So it gets at these concepts, but in such a nebulous way that employers are going to stay pretty far away from anything close to diversity, equity, or inclusion because it's hard to figure out where the line is. So for the implicit bias, you know, they voice that as that an individual by virtue of race, color, sex, or national origin is inherently racist or sexist or oppressive, whether consciously or unconsciously. So getting at the idea of implicit bias. Other prohibited concepts include white privilege or male privilege, that a person by virtue of one of these characteristics is necessarily privileged or oppressed. We think it also pretty clearly targets sexual harassment trainings, that it would discourage employees from the employers commonly, of course, seek to discourage employees from engaging in certain behaviors that negatively affect others based on their sex. And that might run afoul of the trainings because you were focusing on treating the sex of the recipient of the behavior as important to understanding what the impact is. A similar problematic application of this would be with cultural competency training, where again, the training focuses on how does a person of a particular race or sex receive a certain conduct. And so that focus on the particulars of the individual would be prohibited by this law. Similarly, discussions of reparations or restorative justice, the language of the law is that an individual bears responsibility for or should be discriminated against because of actions committed in the past by people of the same race or sex. Similarly, affirmative action policies and DEI initiatives, for example, like trainings that are targeted at women in business in order to provide support in corporate environments that are traditionally dominated by men. Those would also be suspect under this law. And so the way the law functions is that it makes advancing any of those concepts discrimination. So it defines advancing, if the employer advances any of these concepts to their employees, that constitutes discrimination, and then the employee can file a discrimination complaint against the employer. I will just add also that in addition to saying, okay, employers, you cannot advance any of these prohibited concepts, there's a deliberate vagueness added into the law with this catch-all phrase that says, okay, well, while you cannot advance any of the concepts, you can discuss them without endorsement, so long as you don't advance them. And, query, what does it mean to discuss systemic racism without advancing the notion that we should do something about systemic racism, or similarly with respect to any of these other concepts. The net effect of this, and the judge found this in our case in Honey Fund v. DeSantis, the judge found that the net effect is that employers are all going to steer far clear of talking about any of these concepts that are, remotely related to race or sex, and thus, censor a lot of protected speech. So let me talk then about our lawsuit. We filed our lawsuit in June of 2022. The law was set to take effect on July 1st of this year. And just to clarify, because there's been a lot of litigation related to the Stop Woke Act. So you might have heard about other lawsuits that were filed. One was filed the day that the governor signed the bill. I think it was in April of 2022. And that was an omnibus challenge, challenging the K through 12 higher education and employer provisions of the law. That case was unsuccessful in getting an injunction and is largely on hold. They're trying to amend the complaint and sort of figure it out. I think they filed that lawsuit, I'd say fairly quickly, and had some standing issues with some of their plaintiffs. And apart from that lawsuit, there have been two other separate challenges to the higher education provision. So the universities and colleges provisions of the law that were argued just recently by the ACLU, the Legal Defense Fund, and the Foundation for Individual Rights and Expression. And so we're waiting to see the outcome of those cases. And so currently there is no separate challenge that's just to the K through 12 provision. So stepping back then, our lawsuit focuses on the employer provisions of the law. I just want to talk briefly about who our plaintiffs are. So we have three wonderful plaintiffs, and we are so thankful to them for stepping forward to say that free enterprise should have free speech rights, especially when it comes to DEI work, and that they view that speech as critical for their businesses. The first is Honey Fund, which is a honeymoon technology registry company for folks they were featured on Shark Tank a few years ago, and they enable couples to register for donations to a honeymoon fund. And they actually moved to Florida from California because of incentives for tech companies in Central Florida. And one of their concerns was, is Florida actually trying to be friendly to business, or are they trying to demonize business, and asking Florida to please pick a side so they could determine how they should operate accordingly. We're also so thankful to Primo Tampa, which is the largest Ben and Jerry's franchisee in the country. And this is a 100% Black-owned franchisee. They have locations in several states, but this is just the Central Florida subsidiary of them. And they view ice cream, they call ice cream the product, but social justice is, ice cream the medium, but social justice the product. Like, that's the mission. So that they view diversity, equity, inclusion as really critical to all of their work and all of their interactions with their employees. And our third plaintiff is Shavara Oren, who is a diversity, equity, and inclusion trainer herself. So she's the one who is hired by companies to do DEI work. And a lot of her work focuses on talking to businesses about their role in, their industry's role in past injustice and like recompense that they might be interested in making. So she's worked with a lot of banks, for example, on, okay, if you have maybe not made capital available in certain minority communities, like what could you do about that now? So for all of these three plaintiffs, they felt that this law directly impacted their ability to speak. So in our case, what happened? We sought a preliminary injunction, and the court issued a preliminary injunction on August 19th. So currently in Florida, the law is suspended in terms of state officials enforcing it because the court said it's likely unconstitutional. What the court said was that Florida's legislators may well find plaintiff speech repugnant, and that was the word that they used in their briefing. But under our constitutional scheme, the remedy for repugnant speech is more speech, not enforced silence. If Florida truly believes we live in a post-racial society, then let it make its case, but it cannot win the argument by muzzling its opponents. The judge also took some time to distinguish the conduct prohibited by the Stop Woke Act from Title VII claims, because I think the state argued that, well, if this law is unconstitutional in terms of restricting employer speech, so too must be Title VII, which governs employment discrimination. And the court took some time to say that's a conduct regulation that may incidentally burden speech, whereas this is purely, you're targeting like a particular, it's called the Stop Woke Act, you're particularly targeting the act of speaking on expressing a certain viewpoint, and that is, constitutionally problematic. He also noted that for Title VII claims, that speech needs to be objectively and subjectively offensive and sufficiently severe and pervasive to create a hostile work environment, so that protected speech has some greater degree of protection than we would have under this law. And I think that like one of the other kind of core insights that our plaintiffs have brought to the fore for us is that if these provisions of the Stop Woke Act were enforced, then private businesses would find themselves between a rock and a hard place. Because on the one hand, many of you, I imagine, seek to do trainings to combat sexual harassment or racial discrimination under Title VII. And a lot of that is, it provides a safe harbor so that if later your business is sued for racial discrimination, like you can say, well, look, we did this training, we have these policies in place. So on the one hand, we're trying to ensure that there is a racially and harmonious workplace. And on the other hand, the act of doing that may veer into some of these prohibited concepts that the Stop Woke Act is censoring. So the law is on hold for now. The state has appealed the case to the 11th Circuit. We're expecting the state's brief to come in November the 14th, and we expect to file a response sometime in December. The schedule is still being worked out. But I just wanted to talk a little bit about what it is that you can do, how you can help. So we would like to show the governor and all Floridians that businesses reject this kind of overreach and censorship, and that it makes these kinds of speech codes make Florida a hostile place for business. So there's two concrete actions that we think that you can take. The first is that there is a sign-on letter, and maybe we can share in the chat the link to that sign-on letter. It's just a statement saying, this is Stop Woke Act, it's government censorship, and we think it makes it a hostile place for Florida, for businesses to operate in Florida. So we'd encourage you to please take a look at that. And if it's something that your business can sign on to please do go ahead and sign on to it. We're looking for signatures on that letter by like November the 10th. And we're seeking to do some publicity around that statement and the number of signatories. So far, we've got about, I think, 19 signatories so far. So hopefully there will be others. And that's the first thing. The second action that you could take is that we are helping to organize an amicus brief by businesses in support of our plaintiffs, in support of our position opposing the Stop Woke Act. We have a law firm lined up to do that, Margaret Tolles and Olson, and we're also looking at a deadline of around November the 10th, although I think there may be a little bit more lead time because the state has taken longer than we expected to file their brief, so we might have a couple more weeks. But if you're interested in doing that, I'd love to hear from you and follow up with me. And we're planning to reach out to everyone who signs on to the sign-on letter to see if they would be interested in participating in the amicus. And I think that the arguments of the amicus, sorry, just one quick thing. The arguments of the amicus, I believe, are largely one that that the Stop Woke Act censors business speech, and that's a basic First Amendment violation. And then I think it depends on the interest of the businesses that sign on, but could also be a further argument that diversity, equity, and inclusion speech is helpful for business, and there's a kind of commitment to engaging in that speech. Although that'll depend on what the group of amici want to talk about.
Great. Shalini, thank you so much. That's most helpful. Let me ask a question that someone has posed here. Would a successful lawsuit in Florida possibly affect other states like Texas, where the 1619 Project is explicitly banned by name? What impact do you hope that quelching this act might have in other states?
Well, we're hopeful that if we are successful on appeal and the injunction is upheld, that other states will not adopt this kind of law. Like I mentioned, Florida's is the most extreme, and we have thus far not seen other states enact provisions that restrict employers' speech. So if that, we're hoping to guard against that. In terms of the education provisions, that's like separate lawsuits. So it could have a similar deterrent effect, but that's not our case.
Okay, good, thanks. So we'll come back to some of those points, but I just wanted to remind everyone that in the past year, a number of elected officials have made comments about what's appropriate for the business community to do or not do. There have been statements and then consequential retribution and retaliation against companies, not only in Florida for their involvement in DEI training and free speech, but also around voting rights. Marjorie Taylor Greene the other day mentioned that there would be, possibly investigations of companies who had stopped giving to elected members of Congress who had not certified the Electoral College. So, there's a trend here developing, I think, that we need to be mindful of. Let me turn now to Chris Miller. And Chris is the head of global activism strategy at Ben & Jerry's. And I know Chris has been following this issue closely because one of its franchisees is intimately involved in this case. So Chris, when you have been thinking about this from a national perspective, what are the economic implications of what's happening in Florida, and why is this of concern to Ben & Jerry's?
Thanks, Richard, and it's great to be with you and the others today. Let me start quickly just by thanking Shalini and Protect Democracy, who are sort of taking the lead on the legal challenge on this somewhat ridiculous law. Let me just also say how proud we are that Antonio McBroom, the CEO of Primo Partners, who, as Shalini noted, is our largest franchisee in our franchise system, is a plaintiff on the case. And so we're really pleased that he is representing our brand in challenging this law. This is an important issue for us. We have a commitment around issues of diversity, equity, and inclusion in the way in which we run our business. And we believe that that commitment and that strategy is an important part of continuing to build a successful and profitable Ben & Jerry's into the future. Stepping back for a second, I think collectively as a corporate community, we should all be concerned about political leaders who are sort of using legislation and sort of instruments of the state to punish corporations whose views they disagree with. As Shalini noted, this is what authoritarian leaders do. It's not the way a democracy should be run. And what is clear is that it really is looking to stifle speech on one side of the political spectrum. There's a certain kind of speech about issues around gender, sexual orientation, and race. And it's troubling. It really does represent a sort of unprecedented reach into companies and is challenging the way in which we train and develop our employees. An essential part of our diversity, equity, and inclusion commitment internally are a set of goals we have around our employee base, our franchise network, our suppliers, vendors, and agencies. And inherent in achieving those goals is ensuring that our people understand the concepts that undergird the system that has kept Black, Brown, people of color from thriving in our business. And so, the Stop Woke Act that would preclude us from engaging our employees in Florida, our franchise base in Florida, is a big problem. We have a history of doing these types of trainings in Florida. Our annual franchise meeting is often held in Florida, and a part of those have been trainings around issues of the systemic nature of racism. And so it's incredibly important to not just the sort of values of Ben & Jerry's, but for the roadmap that we have to build a more diverse business, which will drive our growth into the future. So, again, it's an important issue. I would encourage all the companies on the phone from Florida to join the sign-on letter and consider being a part of the amicus brief. I think we all have an interest in ensuring that we have the tools that we need to create the kind of companies and cultures that make our businesses future fit. So thanks again, Richard.
Great. Chris, let me ask you, thanks. And let me ask you a follow-up question. So given that you have franchisees across the country, the fact that a law in Florida may stifle the competitive nature of business there, may impact workplace productivity in one state. So how does that affect what you do in Georgia or in Nevada? Or, how can you operate with a different set of rules depending, on the whim of the legislature and the governor?
Sure. I mean, it goes without saying it's not ideal. The idea that you could conceivably have 50 different states, micromanaging the training and development opportunities that we have for our employees around the country is absurd. And so I think what we are seeing here, I think, is less about, wanting to, ironically, as it's sort of positioned, to somehow stop discrimination and racism, but really is about looking to stifle a certain kind of speech on one end of the political spectrum. And so, again, as Sarah rightly noted, this is happening on one side of the political spectrum, not to say that it couldn't happen on the other side. And so collectively as a business community, I think we all have an interest in ensuring that, this kind of sort of political retribution doesn't become a part of the way in which corporations are regulated.
Right. And I assume that, people who walk into a Ben and Jerry's in Tallahassee or in Phoenix or in Los Angeles may have a range of political views, right? So you don't have to be a progressive to eat Ben and Jerry's ice cream, right? And so you are looking to serve the cross-section of the of America and not have a preference as to who your customers are, right?
Yeah, that's right. I mean, we believe we serve the best ice cream in the world, and our scoop shops, which are in states all around the country, really are the sort of anchor of our brand in those communities. And we want to, it's no secret that our company has a strong set of kind of progressive values that guide the way in which we operate our business. But at the end of the day, our scoop shops are places where people from across the political spectrum, the diversity spectrum come, after a baseball game, a day at the beach, and have a great treat.
Right.
So I think, we want to be there for everybody.
Right. Yeah. Let me ask you one final question. We get posed the question often by companies about the potential for blowback. So should they say something about behavior they find objectionable or concerning in this era where democratic traditions and norms are being undermined? They're concerned that it will adversely impact their business, that an elected official may take some retaliatory action against them that impacts the bottom line. So what's your perspective on that, and how are you all accounting for that in Florida?
Yeah, I think, not concerned about it, one. Two, I think this is how authoritarianism takes root. If we're not willing to speak up and have a point of view on, we're not talking about here, a traditional debate around tax policy or the role of government in regulating business. We're talking about legislation that is literally kind of retribution for a particular political point of view. And again, I go back to, we should all be deeply concerned by that. So, are we worried that Ron DeSantis is going to say something that hurts our business? Not really. Governor DeSantis picking a fight with Disney, in a narrow part of his political base that may resonate. But if I'm a betting person, I'm going to kind of think Disney's going to be all right on this. So I think this is how authoritarianism takes root, and I would just say it may not always be easy, but it's important to use our platforms to say this isn't okay.
Great, thank you, Chris. Good. So let's move to Jeffrey Cabaservice, who's with us from the Niskanen Center. We've worked with the Niskanen Center on a number of projects, including a series we did in 2021, seems like so long ago, on polarization. And Jeffrey was one of the panelists in a number of those sessions. So Jeffrey, I know that, as a center-right organization, the Niskanen Center is thinking a lot about the trajectory of conservatism in the United States, the health of our democracy, free speech, and sort of a diminution of these traditional values we've held dear about that make our republic function. So from your perspective, what's at stake here in this lawsuit? Both from a free speech perspective and maybe the health of our democracy?
Well, thank you, Richard. It's good to be with you, and thanks to my fellow panelists as well. It's been very interesting to hear your perspectives. And I'm sure we all send a get well wish to Walter Olson, my friend, who couldn't be here. He would have given you a very in-depth look at employment law, which he knows so well. I'm going to try to elevate up to 30,000 feet and just give you my speculations as someone who thinks about politics from a center-right perspective. I should also add that I am a Floridian, although people rarely identify me as such. I did go to high school there. My friends and family live there, and I actually have had arguments with them about the Stop Woke Act because, generally speaking, people don't like indoctrination, and it's really a sort of question of spelling out what some of the implications of the Stop Woke Act are, where you actually get into the problems of it. I should also add that I saw DeSantis speak at the conference of the National Conservatism Movement in Miami just about a month and a half ago. And without going too deeply into this particular political philosophy, I think it actually is important to know where they're coming from, because DeSantis is the American politician who best expresses their views, even better than Donald Trump, even though the movement is kind of an attempt to retrofit some kind of intellectual justification around Trump's brand of right-wing populism. But essentially, the brief of the national conservatives is that conservatives have been systematically excluded from all of the commanding heights of American society and culture. They have no presence or influence in the media, in academia, in Hollywood, in the largest corporations, and even in the military. And therefore, what needs to happen from their perspective is that conservatives need to abandon their Ronald Reagan-esque belief in the free market and instead wield the power of government as a club with which to smash their ideological opponents. And this is, not the dominant view of the Republican Party yet, but I think it's coming to be that. And if it does come to pass, then we're going to see, number one, a Republican Party that is advancing national legislation to put the Stop Woke Act into effect across the country, not just in Florida. So I don't think we're talking about just what's happening in one odd little gun-shaped peninsula down south. We're talking about something that's coming to your state, quite possibly. And it's also really a sort of big alignment or realignment in our politics, because the Republican Party historically has been the party of business. And I think most business leaders still reflexively identify the Republican Party as their allies and think that the Democrats are trying to impose some kind of socialism. And again, this is a long thread of our history. Calvin Coolidge said the business of America is business. Lewis Powell in 1971 put out that famous memo where he's really calling on conservative organizations to smash anti-capitalist indoctrination in the schools and workplaces. So, what we have here essentially is a new paradigm, and one I think that is very damaging. And I think it actually is really, it's unclear yet as to whether business and the Republican Party are going to go their separate ways. We're sort of seeing how things play out in Florida. And therefore, that's, again, why I think it's important to look at this. One of the things that's worth considering from a perspective as a Floridian is the ways that Florida is actually a state that's actually quite hostile towards big corporations generally. It's a low-wage, low-cost state that actually is turning into a low-wage, high-cost state. But among America's big states, it actually has fewer Fortune 500 companies per capita than do a lot of other states and even some cities, which have more Fortune 500 companies than Florida itself. And there was actually a pretty high-profile case last year where Apple chose to relocate a $1 billion investment with some 3,000 new employees in North Carolina rather than Florida. And that's because essentially North Carolina, although it's a higher tax state, provides what a lot of corporations are looking for nowadays. It invests much more than Florida does in higher education, in infrastructure, in medicine, whereas Florida actually is investing a lot more money in its police forces, let us say. And so basically, what we have here is a Republican Party that's threatening to turn away from so much of what really it lived by from Ronald Reagan onwards, which is a belief in the power of independent corporations to act as they see their best interest without interference from the state. And again, some Ron DeSantis's own ideas are being undercut by the actions of this, because one of the things that the Stop Woke Act does is essentially remove academic freedom protections from Florida's universities. And we've already seen this in action, with Florida attempting to prevent 3 professors of political science from testifying publicly on elections-related matters that are within their areas of expertise. You're starting to see it in Florida's desire to withdraw tenure protections from faculty, as well as to change the certification arrangements for universities. And many corporations are not going to want to go into a state where higher education is under threat in that way. Many corporations are not going to want to go into a state where they will see their ability to draw upon the fullest extent of the workforce possible, and then to try to get that workforce to work harmoniously, again, in ways that they see as being in their own best capitalistic interests. So from a free market perspective, there's a lot to worry about in the Stop Woke Act, and a lot of reasons to look closely at it and oppose its further spread into other states or nationally, as well as to try to work against this kind of anti-capitalist perspective from taking over the Republican Party.
Jeffrey, thanks. That was very insightful. I appreciate those comments. And when you think about the shift from Ronald Reagan and the advancement of the free market to what you described as, focus now on political power, what is the calculation, do you think, about, establishing laws like this, and but also needing to create economic prosperity? So, if Ben & Jerry's chooses to withdraw from Florida, that's not in the state's interest. It's not in its employees' interest. So what's the emerging calculus, you think, within, the DeSantis camp around these types of efforts as far as it impacts the economy?
So I think on the one hand, what we're seeing is an effect of the realignment of the two parties' bases. The Democratic Party, long having seen itself as the party of the working class, now increasingly represents the college-educated professional classes, whereas the Republicans are making ever greater inroads into the non-college educated voter base. And this, to some extent, affects their allegiances. The non-college educated voters, for the most part, do not look favorably on big corporations. And, at the other hand, I think, what we are seeing in DeSantis's political approach has real parallels with that of Viktor Orban in Hungary, let us say. And in fact, at that National Conservatism Conference, one of Orban's chief spokespeople and theorists said what Ron DeSantis is doing is essentially Orbanism in an American context. And part of what Orban is trying to do is reorient the whole political equation, where it is still technically a democracy, and yet the courts are silenced, universities are not free to teach what they want to teach, and also business has to go along with the ideological wishes of the ruling party if they wish to carry on in business.
Right.
So you ask about the economic implications. To some extent, what's baked into the Orbanist model is that you determine the economic outcomes that you want. You see who prospers and who does not in the market. And I think in that sense, sort of dollars and cents calculations are not what someone like Ron DeSantis has foremost in his mind, because at this point he thinks that corporations are basically amoral and cowardly, and their leadership will go along with what the party in power wants. And it has yet to be determined whether he's right about that or not.
Chris, do you want to, Jeffrey, thank you. Chris, you want to offer any thoughts, response to that?
I think it's quite astute. I think it's right on. I think this is a threat in Florida, I think, because of the national profile that Ron DeSantis has and the likelihood that he, is looking to become the standard bearer for the Republican Party. On the other hand, to the degree that this does represent, a sort of shift, it does become a threat nationally. And I think, it's fascinating to watch what has been the traditional alliance between the Republican Party and the corporate community, watching the kind of chips realign themselves. So I think I appreciate very much Jeffrey's perspective.
Right. Shalini, to go back to, the broader national implications of the legislation. So is Protect Democracy anticipating the adoption or the extension of, you mentioned there were 17 states that had provisions restricting what gets taught in an educational context. But are you anticipating, whether this succeeds or not in Florida, that other states in the 23 legislature will pick these ideas up?
I think it depends on how politically successful it is here, frankly. If it is politically successful, then there's a greater chance that other states will adopt it. And it also kind of depends on how quickly Republicans in other states sort of, adopt this anti-corporate stance. So, we saw it discussed in the Texas legislature last session. Haven't seen it seriously discussed in other states yet. So we'll see what happens.
Okay. Yep.
Do you mind if I answer a couple of questions that are in the chat?
Yeah. So the question about the response from the Florida, from Florida employees or employers or employees, do you have any data you can share with us about that?
I don't have data. I can share with you that we have not seen any complaints that have been filed under the Stop Woke Act by employees who, are complaining about speech that their employers have foisted upon them. I will say that the law was only in effect for a couple of months before it got enjoined. So maybe the timing did not quite work out, but we haven't seen that sort of response. And then in terms of the repercussions question, I wanted to just address that pretty quickly. Please. Also. The governor has not been shy about going after companies that oppose him, right? So that's been pretty clear. We think that there is strength in numbers, and we think it is helpful that there is a lawsuit that is ongoing. So there is a public scrutiny, and anything that is retributive will be viewed as such. And we have federal judges involved in our case. So to the extent that any kind of action is taken by, the state against any of the signatories to a letter or to a amicus brief, I imagine we would raise really quickly with the judge overseeing the case to say, you need to do something about this because this is scaring off parties that have an interest here. The other thing I wanted to mention also is in terms of who can sign on to the letter. So the law affects businesses that operate in Florida, but they don't have to be exclusively in Florida. So national businesses that have some presence in Florida, they are also impacted by the law. So anyone who has 15 or more employees, and some of them are in Florida, you are impacted by the law. So we're looking for a broad list of sign-ons, both by companies that operate exclusively in Florida, and then more broadly, like national companies that also have some business here.
Right. And just to clarify, so my company has to have at least 15 employees, but it doesn't need to have 15 employees in Florida. Is that correct?
That's correct, in order to be impacted by the law. I will also say, though, in order to have an interest in this issue, that like businesses' speech should not be censored by the government. You're not acting as a party in the case. You're not a plaintiff. So you don't actually need to be someone who, if your business has 10 employees, but you're concerned about this issue, you could still sign on to the letter. We're not representing that the signatories of these are all folks who, are directly targets of the law. If that makes sense.
Yes, it does make sense. Okay. So we will, those listening, will make sure that, you get not only a copy of this recording, but also a link to the sign-on letter that Protect Democracy has developed, and encourage you all to consider signing that. We're almost at time, so Jeff, anything else you'd like to comment on regarding?
Just that ESG is also very much a target of the conservative movement now. This again represents interference in how you can do your business, but Leonard Leo was the recipient recently of a $1.6 billion inheritance from an electronics entrepreneur. He will be directing all of this at things like ESG and other things that he perceives as wokeness in the economy. And as you said, Richard, at the outset, Marjorie Taylor Greene is calling for inquiries into companies that that opposed as the attempt of Republican legislators to overturn the 2020 election, and this she now characterizes as corporate communism. So this is a moving target as well.
Yes. Yep. So as they say on television, watch this space for a future webinar on ESG. Jeffrey, thank you for reminding us of that. And Chris, any final thoughts?
No, thanks, Richard and Sarah for hosting, and great to join you all.
Good. And thank the three of you, and Shalini, really, we appreciate the work you and Protect Democracy are doing and the leadership on this issue. So thanks, everyone. Have a great afternoon. Feel free to follow up with us with any questions you have, and we'll get back to you. Good day, everyone.